The Supreme Court today struck down the contentious Defense of Marriage Act, which denied federal benefits to legally married same-sex couples. But to the crowds gathered outside the Supreme Court, the ruling had much broader implications.
Today, the United States Supreme Court, in two important decisions, brings us that much closer to true equality.
God bless America! I don't even have words. I'm just so happy and just overrun with emotion. I couldn't be more proud of my country and of the Supreme Court today.
Today is a good day. It's the day I finally get to look at the man that I love and finally say, will you please marry me?
Of course, same-sex marriage has been legal in Massachusetts since 2004, due, of course, to the Supreme Judicial Court ruling written by my guest, former Chief Justice Margaret Marshall. Welcome.
Thank you, Emily.
So, I don't want to say this was, the landmark of your entire seating as the Supreme Court Justice, but you have to feel vindicated in a way. Remember that people were accusing you of being an activist judge. And now the whole world is following suit.
It is remarkable, isn't it? I mean, Goodridge, the Massachusetts Supreme Judicial Court, was, in a sense, the necessary prerequisite. What the Supreme Court did today, and it's terribly important, required some states somewhere to recognize same-sex marriage, and Massachusetts did. And then it was those people who got married, thousands of us in Massachusetts have been married, they were denied just endless federal benefits, and that really brought into play the Equal Protection Clause of the federal Constitution. So the DOMA case, the Defense of Marriage Act case, DOMA being the federal legislation that said that you couldn't give federal benefits to same-gender marriages, that case was not a frontal claim for same-sex marriage as the Goodridge case did. But it's going to have huge implications, huge implications.
You know, I kept trying to figure out what the argument against it was. I mean, this was a 5-4 decision. It wasn't like it was unanimous or killer weighted one way or another. It could have gone either way. What was the argument against it?
It's very hard to articulate. I want to say that in the First Circuit, which is the Massachusetts Federal Court that sits here in Boston, Michael Boudin, Judge Michael Boudin, wrote a really elegant, beautiful decision. Now, he's no raving liberal at all. And it's very hard to articulate the other side. There were some sort of standing questions, but essentially, if you read, at least as I read the dissenting opinions, they don't like the whole idea of same-gender marriage. They just don't.
But they weren't using a constitutional argument.
No, I don't think. They were using a federalism argument. I mean, Chief Justice Roberts essentially says, Justice Kennedy really pointed to the states and saying, marriage, those are the kinds of things that the states have always decided, always, and we as the federal government, we've always deferred to the states. And Chief Justice Roberts says, no, the federal government can decide something of much broader application, even if it has historically been with the states. I think what I found striking about it is if you look at recent United States Supreme Court decisions involving sexual orientation, it was relatively recently, within the last 25 years, that the Supreme Court considered, in a case called Bowers against Hardwick, whether you could criminalize private homosexual conduct. And the court sort of dismissed that. I think the phrase was, it's sort of almost facetious to claim that this is a constitutional right. And what's striking about Justice Kennedy's opinion is how much texture he gives to the lives of same-gender couples who don't have access to federal benefits. He uses words like, this law demeans, it humiliates. That's very strong.
When you really look at the benefits, when it started reading, military benefits, estate tax benefits, Social Security benefits, property tax benefits, estate benefits. Things that people just take for granted if they're a married couple. You get this $5.25 million exemption, but if you're a married couple, you can just hand your estate over to somebody else if you're married to them, but you can't if you're a same-sex couple. You have to pay half of that in taxes.
Absolutely. And one of the...
By the way, will it be retroactive? Can people get their money back?
Well, now, you see, you should have been a lawyer, because that's what... I have no idea what the litigation strategy would be going forward. But that would not be an unreasonable question to ask some court. If I was married in Massachusetts in 2004, shouldn't I be entitled to go back and refile all of my income taxes, or what happened to all of the Social Security benefits that I was denied? That's a very interesting question. The one thing that we know for sure is that there's going to be a lot of litigation over this.
Well, is this an immediate? Does it kick in immediately?
Somebody asked me that, and I don't know. You know, when the Goodrich decision was decided, I don't know if you recall, the decision came down in October 2003, and then it went into May. May
17th.
And one reason the court decided to do that, of course, was because we didn't want Governor Romney caught the next day having to answer questions from every clerk and everybody in every little village throughout Massachusetts. I mean, we wanted to have some kind of orderly process, and I didn't see that in today's Supreme Court case.
I didn't see a date either, but I'm sure it'll follow.
Well, that's pretty difficult because, for example, if you're a tax accountant, I mean, and you've had an extension on your federal taxes, and your client phones up and says, "Can I file jointly?" What's the tax accountant going to say? I mean, so I think that there are going to be a lot of seminars for accountants and lawyers in particular, and I don't think there's a clear answer.
All right, I want to ask you about Proposition 8 in California, because that's something that everybody was kind of waiting for on bated breath with this also. Proposition 8. Essentially, it was a ban on same-sex marriage in California. How did that play out today?
Well, it's a very interesting question because, again, that was an opinion written by Chief Justice Roberts, and essentially what he decided, writing for the court, was that there were plaintiffs who were harmed by Prop 8, in other words, people who wanted to get married, and then the voters took that right away. And the state of California, the Attorney General of California, declined to come in to defend Proposition 8, which took away same-gender marriages. And so the people who had supported Prop 8 came in and defended it. They were private parties. And Chief Justice Roberts, in an opinion which really is consistent with all federal jurisdictions, said, you can't do that. In other words, if there's a statute and the governor in Massachusetts decides that he's not going to enforce the statute, you, Emily Looney, whoever you are, can't come in and say, well, I'll defend the statute. You can't do that. The interesting question is, what happens now? Again, the United States Supreme Court said to the appellate court, the Ninth Circuit, you should have dismissed this. You didn't have jurisdiction. You didn't have the authority to decide this case. That leaves intact the trial court decision. In the trial court, the federal judge declared that Proposition 8 was unconstitutional. So technically, that opinion stands. And as I understand it, Governor Brown has said, I'm going to tell every county clerk to start issuing marriage licenses.
So in effect, it was a striking down of Proposition 8.
Yes, but...
A roundabout way.
A roundabout way, and who knows what happens if the Proposition 8 people go back into court to say, I just don't know.
Okay, but states still have the right, help me out with this, to disallow, ban, whatever word you want to, same-sex marriage. If you know, Wyoming doesn't want it, they don't have to allow it, even with all of this?
At the present time, that's the case.
Because of the federalism.
At the present time, that's the case. There's another hidden issue in here, which is a very interesting issue, is, as a general matter, if you get married in Massachusetts and you move to Wyoming, Wyoming has to recognize your marriage. That's under the full faith and credit clause. In the federal DOMA legislation, there's a provision that says those states do not have to recognize same-sex marriages from states that do recognize it.
But now that's gone.
No, because that wasn't challenged.
Oh.
So that's another round of litigation.
But I mean, even if they don't recognize the marriage, if they file in Wyoming, they can still get federal benefits, whether the state recognizes their marriage or not.
Interesting question.
They can get federal benefits, but maybe not state benefits.
Probably not. If they legally married in Massachusetts and they move to Wyoming, an interesting legal question is, can I file a joint tax return for federally and then a single tax return? I mean, it is complicated. This decision, this area of law has not been settled for all time.
As they say. Well.
Now, what makes it interesting, Emily, is that in the interracial case, that was a frontal attack. So in a case called Loving against Virginia in 1964, the United States Supreme Court said no state can prohibit interracial marriages. That was not decided today, which is why it leaves all these little issues.
All right, Margaret Marshall, thanks for straightening all that out for us.